This is a Power 98.7 podcast. Now we're talking. Subscribe to Power 98.7 podcasts in iTunes or wherever you get your podcasts. There's more on power987.co.za.
It's 25 minutes to 1. This is Power Lunch on Power 98.7. Now we're talking. Let's get into this conversation on our property feature. Carl Liebetrau, Senior Associate Attorney at SBL Incorporated, is on the line with us. Evictions, bank repossessions, and sale in execution in South Africa. What you should know and understand, right? Home ownership in South Africa often involves a mortgage or mortgage, as we call it, a bond agreement. When a homeowner falls into areas on their bond repayment, a bank and other mortgage may seek to repossess the property. If the debt remains unpaid, the bank can apply for a sale in execution, a court-authorized forced auction on the house to recover what is owed. But because such auctions can involve people's primary residences, the process has legal, constitutional, and human rights implications. Now, over time, the courts in South Africa have imposed safeguards to prevent such. So, to tell us a little bit more, we are joined on the line, as I did say, Senior Associate Attorney at SBL Incorporated, Carl Liebetrau. Good afternoon, Carl. How are you?
Good afternoon, Kwena. Happy Monday to you and your listeners. I'm very well, thanks. How are you doing today?
I am good, and thank you so much for taking time to speak to us. We appreciate your time. And I think maybe let's start with the bank repossession in South Africa, how it's handled and how it typically leads to the so-called sale in execution.
Absolutely, Kwena. So basically how it works is in South Africa, if your property has been purchased with finance from a bank, that bank will register something called a bond over the property that gets registered at the deeds office, and that is a form of security for the debt that the bank has extended you. Now, what happens in the context of a sale in execution for a bank, as you quite rightly pointed out, is over a certain amount of months, the purchaser of that property or the owner of that property will fall into arrears with their obligations vis the bond towards the bank. So they'll basically fail to make payment of their home loan installments. And to that end, the first thing the bank will do is approach an attorney who will go and obtain a judgment against the owner in respect of the outstanding amounts, okay?
Mm-hmm.
Then, as you also have quite correctly pointed out, the bank or their attorneys must firstly attempt to enforce that judgment against the owner of the property. Now, to that end, what it typically entails is that the bank will first make an attempt to send the sheriff around to the property and attach movables, or perhaps do something we call the garnishee or an emolument attachment order, which is another method of debt collection pursuant to a judgment. And they will basically, through these methods, try and collect their judgment, okay? And then if these methods prove unsuccessful because they are insufficient assets or they are unable to perhaps get a garnishee or an emolument attachment order, the bank's attorneys will then approach the court for a sale in execution. Now, that is when the court authorizes that property to be sold to satisfy the outstanding amount that is owed to the bank. And as I mentioned earlier, there are safeguards in place because it's sort of seen in our constitutional dispensation as a last resort for the bank. But at the end of the day, if the purchaser or the owner of that house is unable to satisfy the judgment and the arrears continue to snowball, I think you can agree that the bank will be left with no choice but to approach the court and get authorization from the court for that property to be sold And then once it is sold, the proceeds of the sale will be paid over to the bank to cover the outstanding amount, okay?
Mm-hmm.
And I think at this juncture, it's very prudent for your listeners to understand that the process of the bank's sale and execution and the eviction process, those are separate procedures, okay? So once the bank has obtained authorization from the court to sell the property, that property will then go on sale. But during that sale, it is a possibility that the owner or the old owner of the property still resides in the property, and then the person who has purchased the property, normally on auction, they are the party who will be saddled with the eviction, okay? But the eviction will only take place once the property has been registered into the name of the new owner. Does that make sense?
Yeah.
All right, perfect, Kwena.
Okay. So how common are these cases, and which type of homeowners are most affected? Is it purely those that do not pay?
So this procedure is very common. I practice predominantly in the Western Cape Division of the High Court, but I also have many matters in the Gauteng Division. And on any given day on the court's roll, there are numerous sale and executions going on, okay?
Yeah.
Unfortunately, it's very hard for me to give you an answer to what kind of people this affects, because it typically affects all colors, all creeds, all different kinds of people in different ways, okay? People often find themselves, especially in our struggling economy at the moment, people find themselves obviously at a stage in their lives when they were able to access finance from a bank. They would have had to pass the necessary credit control methods that the bank would have installed to sort of, secure the money that they were lending with this house. And those methods are quite strict, okay? So they would have had to pass them. So that just goes to show at a stage in this person's life, it can be said that they were well off financially, or they were certainly well off enough to afford a bond, okay, because a bond is not given away, for the taking. And then, that person might have been retrenched, or their partner had been retrenched, or, it's normally retrenchment is the thing that happens. And that unfortunately leads them to fall into arrears in respect of the bond. And then, the bank will go and foreclose on the bond, or will get a judgment, and will then, if they can't satisfy that judgment, will apply to the court for the property to be sold to try and realize the outstanding amount.
We are in conversation with Carl Liebetrau. We can take your call, 0861 987 000. There's a question here, Carl, and I wanted also to ask it, but Elsie is asking, why are repossessed houses sold at such low prices, not commensurate with what the debtor is owing? As you answer that, how do they determine the price, Carl?
So at the moment in the High Court, in the uniform rules and the case law have dictated kind of steps. There is somewhat of a formula that is used by the presiding officer or the judge in determining how much that property is going to be sold for on auction, okay? And then importantly, cognizance of the fact, cognizance needs to be had of the fact that when someone buys this property, the court has authorized the bank to sell it, and now someone buys it, that new purchaser is going to be saddled with paying the outstanding utilities and rates and taxes that are due to the municipal body. If that was in Tshwane, it would be COT. If it was in Joburg, it would be COJ, City of Cape Town, etc. if the property is in a body corporate, then the levies would also need to be settled by the new owner. And obviously, these are things to take into account if we think of a situation where we are purchasing a property from a owner who has been in a state of financial distress, we can reasonably assume that the municipal account is going to be in arrears. The levies are going to be in arrears if that property is part of a sectional title scheme. But there is a formula to ensure that a reserve price is set, that is an appropriate reserve price, so that the property is not sold for a steal, in other words. And as far as I've seen in the court, the presiding officers are very strict about enforcing that reserve price. So normally when the bank approaches the court, if the court gives authorization for that home to be sold to satisfy the debt, they will set a reserve price. The property will then go on auction for that reserve price. And if it doesn't meet the price, then it is up to the bank to go back to the court and justify why the reserve price for that property should be lower. Does that make sense?
Yeah.
Perfect. And, the courts I've seen, they are fairly considerate, and there is a lot of judicial oversight, especially in the context of these bank foreclosures. And I've even seen instances, it's very common in the Western Cape Division, where on the day of the hearing, the homeowner will come to court and will tender a repayment plan, and they will essentially say, all right, they are going to, they acknowledge that they are in arrears, and they are going to now make payment of the arrears in X amount per month. And then the court will make somewhat of a suspensive order that will say, all right, we will give you 6 to 12 months to make payment of this amount. And if you don't honor your obligations that you've told the court today, only then at that later stage will the bank be allowed to sell the property. Does that make sense?
Absolutely. Allow me, Carl, if I may, there's literally quite a number of listeners that want to ask you a few questions. Please indulge us with a little bit on that. All right. Yeah, I just want to squeeze them in because we might not have enough time. Katlego, good afternoon.
Afternoon, Kwena and colleagues there. Quick one. In case where a homeowner dies while owing the bank and without any form of insurance to cover, and the bank decides to auction the house to cover the cost or the remaining amount. But then in the family, there's someone who qualifies and is willing to buy the house from the bank instead of being auctioned at a giveaway price to a stranger. What is the legal process there?
Yes. Katlego, thank you so much for your question. That's a very valid question. So, Katlego, firstly, what should be borne in mind, is that when someone passes away, an executor will be appointed by the master of the High Court, And normally the deceased, if they have a will, they would have appointed an executor, and that executor essentially steps into the shoes of the deceased person, So that executor is competent to make transactions as if they were the deceased, because now they've stepped into the shoes of the deceased, So, Katlego, how it would work in that scenario is the family member who wants to purchase the property would then go to the executor of the estate and conclude a sale agreement in respect of the property with the executor, But now the problem is that purchase price, the purchase will need to be warranted, because remember, the executor, they have an obligation to make sure that all the creditors, and the bank will be a creditor in respect of that deceased estate, all the creditors realize as much money as possible in that estate. So just to rehash on that question, your best step would be to get that family member who wants to purchase the property. They should urgently contact the executor of the estate, and they can conclude a sale agreement with that executor in respect of the property.
All right. Tato, good afternoon.
Afternoon. So what happens if two parties purchase a property, get separated, the other one moves out, the other one decides to stay there, but obviously the one that has moved out has stopped paying, and the other one that's staying there does not want to sell the house? How do you prevent it from having the house repossessed? Because in that case, then the one that has moved out ends up not getting anything. So how do you force a sale of the house, or if anyhow, or just get something from the house if the other one doesn't want to sell, to prevent this from happening?
Carl, you got that?
Yes, I've got that question. Thanks, Tato. So, Tato, I'm assuming that the bond is registered in the name of both of the parties. Okay.
Yes.
So to that end, the parties will normally be jointly and severably liable for the bond. Okay. So the bank is not going to concern itself with whether, the parties have split up or what their situation is. At the end of the day, the bank just wants their money. And, they would see that as somewhat of an internal arrangement between the parties. But if you are really struggling, it is possible to, if you're really struggling with the other party and getting them to honor their obligations with the bond, it is possible to approach the High Court for something called an actio dividendo, which is a fancy Latin word, but it's a cold common law application or an action where you give justification as to why the co-ownership in the property should be split, okay? And then
so it's the judicial partition of co-owned property. The actio commune dividendo.
Yes.
All right.
The other thing would just be to try and negotiate with the co-owner of the property. How can we sell this property? Because you want to take steps to mitigate against the arrears growing too much. Because ultimately the bank, is going to go after you, and then you want to, if at all possible, if you are struggling to make payments to your bond, it's best that you try and sell that property on the open market rather than letting it go through the auction procedure, okay? Because on the open market...
Just on that...
Okay, go for it, Tato, quickly.
The other person does not want the property anymore, but the other person wants to stay there and doesn't want to sell. Do you just go to the bank and say, I do not want to be part of this bond?
No, unfortunately, you can't just absolve yourself from the bond that you would have committed to. So, in those situations, so you're saying that one person wants to keep the property and the other one
wants to
sell.
sell.
The other one doesn't.
Okay, but then the person who wants to keep the property should buy the other party out, okay? So you can either do that through negotiation with the other party, and if the negotiation is not possible, then you would do that actio dividendo thing that I just spoke to, but you would definitely need an attorney to assist you with that.
All right. Thank you, Tato. I'm going to take Jonathan in Roodepoort. I do apologize. There was quite a number of callers, but we can't go through them. There's literally 5 minutes left on the chat. And Carl, maybe we can make some more time sometime soon so that we can accommodate others. But we'll talk about that right now. Let me take...
Absolutely, Kwena.
Okay, thank you so much for that. Let's take Jonathan in Roodepoort. Go for it, John.
Hi, thanks, Kwena. I just find out, in a situation where the court grants the bank an order to sell the house at an auction at a lower price, then the new buyer obviously settles the rate and all the outstanding debts. What happens then to the previous buyer's debt? Does it get removed automatically, or does the previous buyer still get to owe the bank?
You got that, Carl?
So yes, I've got that question. So the liability vis the municipality and the levies, that would be considered settled, okay? But remember, the bank will have a full claim in terms of the outstanding amount on the bond plus interest, okay? So the bank will always have that claim, and this question depends. It's on a case-by-case scenario. It depends how much the property is sold for, okay? So obviously, if the property is sold for, say, R500,000, and you owe the bank R1 million for the outstanding installments in terms of your bond, as well as interest, the bank will then have a claim for the balance. Does that make sense? For the amount that basically hasn't been covered by the sale. So to that end, it's even more important that you know, if you are falling into arrears, it's very important that you try and sell. If you simply cannot afford to make payment of the arrears, it's very important that you try and sell the property on the open market. And what you will see is a lot of the banks nowadays, they have made available to people who've got bonds with them facilities that assist the owners selling the property on the open market that will allow them to realize a somewhat more of a market-related price than if the property was to go on sale at auction. So I hope that answers your question, Jonathan.
Well, yeah, indeed, Carl. Just then, I wanted to wrap this up with one extra question, at least from my side. Is there a way that people can get maybe information when they have these issues, like, is there anywhere else where people can get information, or it will have to be maybe with somebody who understands legally from that perspective?
You could look on Google. There should be some great advice there. But what I will say is that if you are falling into arrears, in respect of your bond, you shouldn't be an ostrich and dig your head in the sand. You should reach out to your bank and be transparent as possible and clear as possible. And if there's doubt as to your ability to make payment of those bond installments, before you allow the amount to snowball, you would be best off trying to sell that property on your own with an agent, or perhaps one of these bank-appointed agents or programs that the banks have set up can assist you, because you don't want to be saddled with these legal woes, And, by the time these banks are big institutions, so by the time your matter is in court, remember it's now with an attorney. So the communication with the bank and the attorney, in my experience, can be quite difficult, and everything is quite slow, So you want to engage with the bank directly as far as possible when you can. Okay.
All right. I'm going to squeeze in. I thought we were done with this calls, but very, very quickly. Elsie, I literally have a minute. Go for it.
Okay, if the owners do not want to move out, what help is there for the new owner to get them evicted? Is it left to the new owner or by herself, or what?
Okay.
Thank you.
Carl, very briefly, if I may, also from your side, yeah?
Yes, so I'll see the new owner, they would then be saddled with the eviction, okay? So the new owner would approach an attorney, and they would give I'm assuming it's the old owner who's living in there, or maybe tenants of theirs.
Yeah.
But they would give the people living in there a full calendar month to vacate the property.
And if they refuse to leave?
If they refuse to leave, you then issue a PI application, an eviction application in the High Court or the Magistrates Court.
So who should, is it the bank or the new owner?
The new owner, not the bank. The new owner is the one who's going to be saddled with that.
Carl, we're going to have to do this some other time. We will be in touch.
Because we can do it again.
I think we need an hour to do this. So we will definitely set some hour aside so that we can accommodate all the other people. Because I also asked only 3 questions from the ones that I had planned. But thank you so much, Carl, for making time. Appreciate your time.
It's a pleasure, Kwena. You have a wonderful week further. Thank you for the opportunity.
And a good one to you too. Liebetrau, Senior Associate Attorney at SBL Incorporated. It's 2:00. Here's Nhlanhla.
Power News.
Thanks a lot, Kwena. Top stories at this hour. Former Ekurhuleni City Manager questions EMPD acting head's authority over agreements, and Limpopo Premier.
You've been listening to a Power 98.7 podcast. For more podcasts, visit power987.co.za or subscribe wherever you get your podcasts.